Thank you so much, and thank you so much for your kind invitation. Can you hear me well?
Yeah, we can hear you.
Okay, great. So yes, the title of my presentation is Fundamental Animal Rights, proposal by the Finnish Animal Rights Lawyers Society. So I'm going to give my presentation in terms of animal law, in other words, in terms of law. I will present the proposal in main points, and I will be focusing on the three principles: the principle of precaution, necessary, and proportionality in my presentation. I hope that I don't use words, legal words that you can't understand, but if I do, please ask me afterwards, after my presentation, if there is anything you can't understand. I would also like to thank you the previous presentations about the animal stories, because that makes everything more meaningful. So thank you. Unfortunately, I will not have any animal stories here. For some reason, now it's working. Okay. So I explained to you first a little bit about the Finnish legal system, so you can understand why the fundamental animal rights, the recognition of them is so essential. So the Finnish, or maybe Nordic, legal system is based on the statutory law system, meaning that the norms in the legislation is based on a hierarchy where the norms are in a special relation to each other. All of the animal protection legislation is based highest on the norm hierarchy on ordinary law level, acts, decrees, and other regulations based on acts. So we don't have in the Finnish Constitution anything about animals. Indirectly, in the section of the protection of the environment, animals living in and by the nature, in other words, the wild animals, are mentioned or incorporated in that section. But directly, there is no sections, no provisions about animals in the Finnish Constitution. So all legal decision making in Finland, based on the statutory law system, is bound by the EU and the Finnish law, which is interpreted and applied in accordance with the hierarchy of norms. However, both the EU legislation and the Finnish animal protection legislation is based on the welfare paradigm, as we all well know. And this means in connection with the fact that there is no provisions in the Finnish Constitution that compared to humans, because the human rights and freedoms are regulated in the Finnish Constitution. This means that as an outgoing point, the animals are legally in much weaker position than we humans. So from an EU law point of view, in the Treaty of the Functioning of the European Union, Article 13, the animals are recognized as sentient beings, but regarded in legal terms as objects, things, and or property. So, and that is actually the essence of the welfare paradigm, that we are allowed as humans to use and exploit animals legally, even if we recognize them as sentient beings. The objective of the Finnish Animal Protection Act, the highest level in the norm hierarchy concerning animal protection in Finland, is to protect animals from distress, pain, in a best possible way, and also to promote the welfare and good treatment of animals. Generally meaning that animals have a weak legal status in relation to human interests and fundamental rights, as we also well know. So the question is, how is the law actually protecting, or who is the law actually protecting? Is it actually more protecting human beings and human beings' use of animals? And this was something when I studied law, public law, I was very much thinking many years about that. What is it in the legal system and the legislation that makes this possible? Where is the keys to change this? The fact is that we know today that we have more legislation both within EU and in Finland to protect animals. We have never had so many statutes, so many provisions, so many acts, so many decrees to protect animals. At the same time, we use, we kill, we slaughter, we exploit more animals and destroy our common environment at the same time, as we also well know. And we are causing pandemics, as we all also well know by today. So what is wrong with the legal system or the provisions, the acts, that this doesn't function? The good objective or aim to protect animals is actually not protecting them from human violence. And this was the reason I wanted to change it. I was almost ashamed of how weak the legislation was. At the same time, when the wording in the legislation sounds so very good, to protect animals in the best possible way and to promote welfare and their good treatment. So this led to that during 2016 and 2017, legal scholars in Finland, we started to write a proposal of a new chapter for the Constitution of Finland on the fundamental rights of animals. My thinking of that time when I asked my colleagues to start this project with me was to concretize and give the lawmakers a package which is ready to use or at least discuss. So during 1.5 years, almost 2 years, we wrote the proposal, and the aim was to firstly define what the Article 13 in the Treaty of the Functioning of European Union, what does that recognition of animal sentient, what does that mean in legal terms? So that was one aim to do in the proposal. And then also to lay down the principle of precaution, principle of necessity, and principle of proportionality in terms of animals' fundamental rights. And then when we finished this work and we asked also different legal professors and legal scholars to comment and give their feedback on the proposal. And when we, in 2018, was thinking that now we have done what we can at this moment, I was asking, what now? What shall we do with the proposal? And that was the moment when we established the Finnish Animal Rights Lawyers Society and starting lobbying for the proposal, both for general public and also for the lawmakers. The proposal contains 5 sections. First one is the general section concerning the protection of animals, also establishing the principle of precaution. Second section is about safeguarding the fundamental rights of animals, which is directed at mainly at the authority, but also laying down the principle of necessity and principle of proportionality. And the third section is about fundamental rights of wild animals, or those animals that are living in and by the nature. And the fourth section is about the fundamental rights of animals dependent on human care. We didn't want to use the word domesticated animals because one can actually question also the domestication of animals. And the fifth section is not directly a right for animals, it's a prohibition on breeding. I briefly go through the proposal because we don't have time for everything, but you can find on the Society's webpage, you can download the whole proposal. So the protection of animals and the principle of precaution means that all animals shall be presumed to be sentient unless otherwise can be determined. That means that because scientifically we don't have a strict line between those that are sentient and those that are not. And therefore, we wanted to establish the principle of precaution and turn it over from maybe what it is today and say that all animals should be regarded as sentient unless we can't, by science, prove the contrary. And that would be the outgoing point for all of our actions. Is it the lawmaking on ordinary law level, or is it the interpretation of the provisions, or is it the application of the law or legislation, or any other decision making, or our actions towards animals? So it should be outgoing from that principle that all living beings around us are sentient, if not proved contrary. In my personal opinion, the second subsection of section 1, the interest and individual needs of animals must be taken into account in all private and public activities that have a significant impact on their living conditions or changes of survival. I think that subsection is the most important in the whole proposal, because that means that when we motivate our actions, we have to take in that discussion also other sentient beings. And the principle of necessity, that means that fundamental animal rights may only be limited if it is necessary for safeguarding the fundamental rights of human beings or animals. So, for example, it couldn't be allowed to kill or slaughter or actually even breed animals if it's not necessary to safeguard our own survival for self-defense, or to protect some other animal individual, or to safeguard or protect some other species. That is one example of the principle of necessity. And that, of course, and I'm not saying with this that there wouldn't be maybe situations or practices that are necessary to do and is causing that we are taking, for example, animals' life. But that would be more, this provision or this section, subsection, is forcing us as human beings to think what is necessary to cause other sentient beings. And if there is any limitations of the fundamental animal rights, then they has to be as minor as possible with regard to the pursued aim. In other words, it should be so minimized as possible. That is the principle of proportionality. Fundamental rights of wild animals, in short, right of life and the right to live in freedom in animals' natural habitat, but also the right to receive help if the animal is sick, injured, or otherwise incapacitated. And if an animal is in a condition such that keeping the animal alive is obviously cruel, the animal has the right to be euthanized. And in that case, it should be killed as laid down by law. In other words, by provisions laid down in an ordinary law level. The fundamental rights of animals dependent on human care includes in total 9 rights. Right to live to a life, as well as the right to express natural behavior and have the animal's basic needs fulfilled. Right to experience and express positive emotions, and right to be protected against and free from fear, pain, distress, and suffering caused by humans. Right to food and drink, right to decide when to eat and to drink. Right to suitable living environments, which includes also shelter and a resting area. And as wild animals, right to receive appropriate treatment without any delay, and right to be euthanized if the condition of the animal is such that that is the only good way to handle the situation. And the 5th section, prohibition on breeding. An animal may not be bred in such a manner that the breeding would cause the animal or the animal's offspring physical or physiological harm, or prevent the natural behavior of the offspring. Prohibition of animal breeding shall be laid down by law, meaning again by provisions in the ordinary law level. So in legal terms, according to the fundamental rights of animals, this means that acts and provisions of a lower level than an act has to safeguard animals' fundamental rights. In other words, the decrees and other provisions. It's, in other words, binding for the legislator. The public authorities has to safeguard the rights both in the implementation and application of the law. In other words, binding for the public authorities. Everyone is to be responsible for the safeguarding of animals' rights, welfare, and protection. In other words, binding for the human individuals. The principle of precaution, necessity, and proportionality limits the animal use for human purposes. In other words, promotes respectful coexistence between humans and non-humans. often representatives from the media, journalists, are asking me, but what if we recognize the fundamental animal rights, then we cannot blah blah blah. And I usually answer, yes, that is exactly what we should do, and therefore we need to recognize the fundamental animal rights. And most importantly, animals' legal status is strengthened in relation to humans. In other words, establishes in practice legal subjectivity. I end my words with something I wrote down in my doctoral thesis. Everything concerning animals, and especially concerning animal law issues, it is not a question of how much they can suffer, how much animals can suffer, nor what they can feel. It is all about that they are sentient beings. Thank you for your attention, and I'm happy to answer your question this may have raised.